Good morning, everyone. Today's Friday, April 3rd, 2020. It is approximately 10:41 a.m., and welcome to our daily podcast. Today's topic is specifically on the area of attorney's fees and how family law matters is different from your typical standard attorney. I'm joined here by Gina Famularo. I will give her an opportunity to introduce herself. I just want to make sure I remind the participants and the viewers that this recording, if you're unable to join, will be posted on all of our social media websites. It will also be posted on our website. So if you're unable to join or unable to or had other obligations, please feel free to visit our website, our YouTube channel, or our Facebook channel. Gina, let's start with the intro. Tell us about yourself.
Sure. My name is Gina Famularo, and I'm a family law attorney for the last 22, nearly 23 years. I've exclusively practiced family law that entire time. I'm a partner at Family Law Matters. The first 9 years of my career was spent in Orange County. The balance has been in Riverside County.
Thank you, Gina. And I am Bishoy Shahada. I'm also an attorney. I'm the managing partner at Family Law Matters. I've been an attorney for a little over 2 years, and all I know is family law. So, Gina, let's get straight to the topic. Attorney's fees. We're here to talk about how they work. So, tell me, how do most attorney fee agreements work?
Sure. Most attorneys, when you walk into their office, will ask for a retainer. Sometimes it seems small, like a $2,500 retainer. That sounds affordable. So many times people will walk in with the expectation that attorney's fees will be lower because the retainer agreement is lower. How it works is that money is put into an account, a trust account, and cannot be touched until the attorney's fees are earned. That's a great incentive for the attorney to do work on your case. They bill you at an hourly rate. Nowadays, $400 is the going rate. Many attorneys are $450, even $500. If an attorney bills you at $400 an hour, what you're looking at is being billed in what we call 0.2 increments. That means that anytime you make a phone call to your attorney, you're being billed $80, even if that phone call is 1 minute. If the attorney, let's say, reviews a letter from opposing counsel, they're going to bill you 0.2 to review the letter, 0.2 to send you the letter. That is a $160 letter. Anytime you walk into the attorney's office and you request a meeting, you're looking at a minimum of 0.5 hours. That's the $200 meeting, even if that meeting only lasts 5 or 10 minutes. If you go to court, attorneys typically will bill you what we call portal to portal, from their office door to their office door once the case or the hearing has been concluded. That's usually 4 hours or $1,600. They do the same for their staff. If they have a paralegal, paralegals these days bill at about $175 an hour. So a phone call with a paralegal is $35. And as you can see, that adds up very, very quickly. In addition, the attorney will have money sitting in a trust account that they can't get to. And so it incentivizes them to do work on your case at the outset. What that means, practically speaking, is by the end of the month, most of your retainer fees will be gone. And so then in month 2, you're going to be asked for a new retainer to replenish the account. And another $2,500 or $3,500 will be due in month 2.
So when the attorneys ask for the retainer, I know that locally, at least Riverside County, oftentimes that retainer is low. I've seen it go as low as $1,500. Can you explain or elaborate a little bit more about the first 3 months of the case and what that typically means and how long that initial retainer may last?
Sure. Well, if you're putting $1,500 down on a retainer, let's say, and your attorney is billing at $400 an hour, most likely you're going to owe money at the end of month one. That $1,500 retainer is not even going to get you through month 1. So then in month 2, you're going to get a bill not only for the portion of attorney's fees you haven't paid in advance because you owe money for month 1, you're also going to be getting a bill to replenish that retainer for additional money over and above what you did not pay for in advance. Most people, when they see that the $1,500, if we're going with that example, wasn't enough to even cover the first month, they're going to want to put a break on their case. Month 1, they're asking questions, they're engaged with the attorney, they're participating in the proceeding, they're providing documents to the paralegal, they're meeting with their attorney, but then they get the bill in month 2, and now all of a sudden they no longer want to cooperate. Usually what happens is they want to put a break on the case because now they are realizing how much their attorney's fees are going to be, and it's terrifying. It doesn't allow them to budget for how much money they're going to spend. And then typically in month 3 or 4, they've got a court appearance coming. So month 1, they're engaged. Month 2, they're shell-shocked. Month 3, there's a hearing coming around that needs to be prepared for. So there's going to be some attorney's fees, but the client is not going to want the attorney to spend a whole lot of time on the case. And then month 4 is that hearing, and there's going to be a huge attorney fee bill in month 4. So typically what happens with a monthly retainer, with a advanced retainer, as most people bill, is you have this roller coaster: high fees, no fees, high fees, some fees, high fees, because it builds up energy. There's pent up energy. The client is delaying his work as long as possible, but then something comes around that's unavoidable, and the attorney has to do work on the case. It's very difficult and for the clients to be able to pay for the entire proceeding because it lasts so long and it's so expensive and it's so difficult to budget. So in traditional retainer fees, it's very common to see a client start with an attorney, but by the end of the case, finish it on their own because they just simply can't afford the outrageous amount of fees that they're incurring.
So when you're talking about the billing and I don't want to call it excessive billing, but the high amounts of billables, let's dissect that a little bit more. So if my attorney and my paralegal are meeting to discuss my case, am I getting billed for both?
Typically, yes. Some attorneys will only bill for their time. They will not bill for the paralegal's time when the two meet together. But the common practice is you would get 2 bills, one for the paralegal at $175 an hour, one for the attorney at $400 or $450 an hour.
And if my attorney calls me and leaves me a voicemail because I was at work, am I still getting billed for that?
Absolutely, in increments of 0.2, which means that you're getting billed $80.
Wow. Okay, so let's talk about the retainer portion. The retainer fee that is paid up front that's put in the trust account. Are any parts of that refundable?
Yes. Anytime that there is a retainer that is paid towards attorney's fees, the amount is refundable. However, practically speaking, because the attorney is getting a large amount of money up front that they cannot touch, again, it incentivizes them to do work. Therefore, it's very common that if you hire an attorney and a couple weeks or a month later, you decide that you no longer need that attorney's services, it's very common that there's nothing left in the trust. In fact, you could even owe money over and above what was in the trust originally.
Thank you, Gina. Now I want to shift gears to how family law matters bills. So let's start with how is that model set up?
Sure, we bill like a gym membership is how we describe it. We bill for a sign-up fee, and then we bill a monthly membership fee. And the advantage to that, as you know, Bishoy, is that it allows clients to budget. They know exactly how much they're going to spend on attorney's fees each and every month because it's consistent throughout the entire case.
So is it a flat fee or is it a true retainer?
That's a good question, and there's been some debate about whether it's a flat fee or a retainer. I think you could call it either. A retainer is an amount that is put down on towards attorney's fees that's non-refundable.
A true
It
retainer,
is,
just to clarify.
yeah, a true retainer.
Okay, thank
It
you.
is like a retention fee, which is how we relate our sign-up fee for our monthly membership. There's an amount that's paid down, which retains us because we have a limited number of attorneys, or I'm sorry, yeah, a limited number of attorneys and a limited number of clients that we represent. So if you want to secure a spot in our office, there's a down payment. However, you could also call that a flat fee because that amount, that down payment, gets you through month one. So it's a flat sum for month one. And then for every month thereafter, it is a flat sum, whether it is 1 month, or I'm sorry, 1 hour or 100 hours that we bill, it's the same flat sum. It's also a true retainer because that one flat sum secures our services for that 1 month.
So I want to dissect the two, and I want to separate because you talked about an initial retainer, and then you talked about a reoccurring, what you call the membership fee once a month. So let's dissect the retainer a little bit. You said the retainer secures the availability of the attorney for that month or for the services as a whole. So is it allocated towards any specific work?
No, it's allocated towards whatever work is needed in that 1 month. Sometimes it might be a domestic violence trial. Other times it might be preparation of the initial documents to start a case. Some people come in the middle of the case and they've got discovery pending, or they've got a responsive declaration that needs to be prepared. Whatever is needed during that 30-day period, that money is allocated towards. So we don't bill by the hour, we bill by a period of time.
Okay.
In 30-day increments.
And my understanding is that that initial retainer sum, that initial payment sum is non-refundable, correct?
Absolutely, it's non-refundable. Again, it's either whether you call it a flat fee or true retainer, it is a sum certain for a specific period of time. But when you look at it in the scheme of things, it sounds scary to put down money that is non-refundable retainer, unless you compare it to how other attorneys bill. They'll give you an amount for a retainer, which is typically comparable of our retainer amount. They tell you it's refundable, but again, they're incentivized to use up that retainer in the first month. So practically speaking, whether or not you use us and you put money down towards a non-refundable retainer, or you use another attorney and give them a refundable retainer, at the end of 30 days, both of them are going to have used up the money.
So then the advantage, the biggest advantage that I'm seeing, and I think you hinted towards it, is that moving forward, you know how you can budget. You know exactly the amount that you're going to be charged every month, whether it's 1 hour of work or 100 hours of work, or whether you have 1 court appearance versus 3 court appearances. It's still the same amount. It's still the same membership fee, and everything is covered in it. Is that true?
Yeah, I think there's huge advantages to the way we bill, Bashoy. That's one of them for sure, is the fact that the clients can budget. They know exactly how much they're going to spend each and every step of the proceeding. Furthermore, it incentivizes the client to push the case forward. It incentivizes the client to participate in their own legal proceeding. When you have a case that is being billed by the hour, it incentivizes the client not to participate. In other words, you're then operating under emergency circumstances. You're always going from crisis to crisis, and you're not getting ahead of the situation because the client doesn't want to be billed by the hour unless they absolutely have to. In our model, The clients are billed whether or not they participate. So they're going to want to squeeze every ounce of money, every ounce of value out of their legal fees as possible. So when our clients call us, they know that they're going to not be billed. When we call the client, they know they're not going to be billed and that it's going to accelerate their case, and they're going to be able to get rid of us quicker. Because by participating, we're able to settle the case, we're able to be prepared for court, we'll be able to be prepared to address whatever issues come up. So I think that is an enormous advantage.
Thank you, Gina. And then with that said, should people or potential clients hire Family Law Matters just for that structure?
Absolutely not. They should hire us because we're the best around. They should hire us because we've carefully picked our attorneys, we've carefully picked our staff, and we have all superstars. We care, we know the area, we're very good at our job, and truthfully, the way that we bill is just icing on the cake because it allows people to budget.
Thank you, Gina. And I think that concludes. So again, there is a perk, but I think to Gina's final point is that hiring an attorney based on price isn't a smart decision. You should hire an attorney based on your comfort level and the experience of the person that you are hiring. Again, thank you, Gina, for taking the time. I do want to let the participants know that if they do have any additional questions, they're more than welcome to email us, to send it to us. They can get in touch with us. They can schedule a consultation on our website, or they can call our office at 951-587-0505. Our website is Temecula Divorce, www.temecula-divorce.com, or you can email us at info@temecula-divorce.com. Again, this recording will be posted on all of our social media websites, and please continue to send us your questions. We'll continue to post our podcasts and answer those questions for you. Thank you again, Gina, for taking the time.
Thank you, Bishoy.
God bless us all.